Yes, so yesterday, for those who had the opportunity to sit behind the television, you saw a lot of things happen at the chamber, the Supreme Court, and it was very exciting, very interesting moment. So you notice that at some point in time, this whole matter started from, let's say, 17th of October, when the Speaker of Parliament declared 4 seats vacant. But before then, Afenyo Markin says that he filed some processes at the Supreme Court.
Yeah.
And the processes were left on the table of the Parliament, the legal service department, on the 16th. So it turned out to be that, or the argument is that the Speaker is aware of the pendency of case at the Supreme Court before he went ahead to declare those seats vacant. Then Afenyo Markin and his lawyers went to the Supreme Court with an ex parte motion. The Supreme Court upheld it and said, look, whatever the Speaker has done, stay. It shouldn't take effect, for that, which means that Parliament should be as it is. Following that declaration, there was a change of position.
Change of position.
Absolutely. The minority now become majority, and the majority now become minority.
If the Speaker's declaration of the seats vacant,
absolutely.
is anything to go
And
back?
the Supreme Court said, no, let Parliament be as it is until final determination of the case. A whole lot of controversy.
What happened before that? Because we know that in the aftermath of that declaration, Afenyo Markin went to court again, right? And this time around, the Supreme Court was able to sit very swiftly and then give a certain directive to the Speaker.
So within the settings of the law, one thing is that the reason it's an ex parte is that something is happening, and you think that if the court does not intervene, there will be something will go wrong or something will go amiss. So this time, with an ex parte, you are going on the blind side of the other party. So Afenyo Markin went to the Supreme Court on the blind side of the Speaker.
On the blind side of the Speaker, on the blind side of Parliament.
Parliament.
With an ex parte motion. What was the ex parte motion for?
The motion is that, look, whatever the process that the Supreme Court has, the Speaker has taken, the law doesn't allow the Speaker to declare those seats vacant, looking at the constitutional provisions that they made available. And if you look at that, they are saying that for the Speaker to go that way, it means no, it must not go that way. So the Supreme Court should intervene. That's why the Supreme Court, the Speaker, stay whatever you have done. We'll deal with the matter until the final determination of the matter. Let Parliament be the way it is. Then the lawyers of the Speaker said, no, the decision of the Supreme Court is alien. It is not bound of law. The Supreme Court does not have jurisdiction to do that. To
tell the Speaker to stay a decision of declaring seats vacant. The Supreme Court can't do that. That's what the Speaker of Parliament believes.
Absolutely. And so the Supreme Court does not have jurisdiction. They also believe that that particular position taken by the Supreme Court breached the rules of natural justice. And so it cannot be made to stand. So they went with
the rules of natural justice because it was ex parte, and the side of the Speaker was not heard.
The other party ought to be heard, and they didn't. So there was no balance. But of course, it's an ex parte motion.
For the avoidance of doubt, ex parte means going to court without telling the person
other party,
you are taking to court.
No.
You go to court on his blind side.
Yes, let the court know that something is happening, and I want the court to intervene. So that you'll be there, and the court, you'll be informed that this thing that you are doing, the court says stop.
Right.
Meanwhile, you have not been heard.
Right.
You need to then be put on notice. So the Speaker and the lawyer said no, led by Title Story said no. We are going back to the Supreme Court. For the Supreme Court to set aside that decision they took on the 18th of October. Now, yesterday was the day that the case was fixed for here. Remember, the substantive matter is still pending. And a 5-member panel, Chief Justice Gertrude Sagitokonu, presided over the case. Then we had Justice Mariama Owusu, Justice Samuel Esiedu, Justice Enes Gao, whose membership or inclusion in the panel became a subject matter of contention. Then we have Justice Yao Dakun Asari. So these were the 5 that dealt with the issue. And initially when the matter was called, the first thing that came was an objection from the Attorney General. He says that, look, 2 paragraphs within the statement of case or affidavit in support of the Speaker's case had issues. One, it is scandalous, and the other one is also very offensive because of the wording and the kind of phrases that they use in there. The Supreme Court said, no, we won't take a ruling on that. So at the point in time, you notice that they retired. Before they retired, they also made a point about, they raised questions that the lawyers of Speaker about and Justice Enes Gao's inclusion, and said that, look, this is somebody who is associated with a known political party.
So they were objecting to his
inclusion.
empaneling or his inclusion on the panel of 5 judges sitting on the case.
So
Justice GHOne.
Absolutely.
So Thaddeus and the speaker said he is not fit to be on the panel.
He must not be there. So they argued. Then the Supreme Court retired to come out with their decision.
So they argued that he's not fit to be on the panel because...
And they don't feel that if he's part of, he will take a decision that will be fair to the parties, particularly them as those who are applying for, because for somebody who is a member, and notice that this whole controversy that confusion that we are talking about, stands between Afenyo Markins, who is a member of the MPP. And they feel that this particular judge, who is associated with the MPP, may not do due diligence or will not be fair to them. For that matter, they do not think that his inclusion is something that should be justified.
So essentially, Thaddeus' issue is that Justice GHOne, or is GHOne, was one time a parliamentary candidate for the NPP.
Absolutely.
And because of that, he is an MPP member, has been associated with the NPP. And because of that, he should not sit on this.
On the panel.
So that was an objection that he raised.
Absolutely.
Right.
So the Supreme Court put the two together, the objection to the 2 paragraphs and the issue about Justice GHOne. They retired, came back, and they said, look, the issue about the objection, we'll take it together with when we are done with the entire hearing of the case, we are coming out with our decision, we'll deal with the objection. But the issue about the panel member being associated with that, the Supreme Court made instances to a member of the Supreme Court who is a known PNC member for ages, all decisions that he has
been a former chairman of the PNC.
Absolutely, and we know who that person is. Justice Gabriel Palmer has always been there. He also made mention about a former Supreme Court judge who has been an MP, a member of parliament for one political party. And so, in effect, what the Supreme Court was saying, or the panel was saying, is that it doesn't matter whether the person has been affiliated to a political party or not. All that matters is the person doing due diligence to the law, is the person conducting himself that will show that he knows what he's doing and his decisions are in accordance with law. So for that matter, that particular request was rejected. Then opportunity came for the parties, the speaker, to move his motion. Then Thaddeus moved the motion. And by way of moving the motion, he stated the grounds: 1, Supreme Court did not have jurisdiction, and if anything at all, that particular ex parte motion should have come on notice, but there should have been a motion to attach which says that seeking an abridgment of time. For instance, if the initial processes went foul and the case will be matured in, let's say, 8 days' time or 2 weeks' time, abridgment of time means that you can compromise and bring the time forward, let's say 2 or 3 days' time. They are making the point that it should have come on notice, but then a notice of our application for abridgment of time should be attached so that it could be dealt with expedition. They do not think coming ex parte is the way to come. Then the other leg was that they breached the rule of natural justice. Lawyers for Afenyo Markins, led by, in fact, Jogate led the team, but it was Pakwisi Abedu who advanced argument. And he said that, look, everything points to the fact that the speaker has been made aware of the pendency of case at the Supreme Court before he went to deliver that ruling in Parliament. And so to say that the speaker is not aware is neither here nor there. So the Supreme Court should state that particular or should affirm their decision taken earlier. Then the Attorney General, Godfrey Adami, also came in and said, look, these whole things that you are doing, it is an offensive to the procedure of the court. And so that application from the speaker, it's unwarranted, and the court should dismiss it. And then the panel rules, they retire. There was a forth and back, seeking clarification, giving the parties at a point in time, the court said 10 minutes. At a point in time, Thaddeus' attention was drawn that you've done close to about 20 minutes. The Attorney General started. At the point in time, Thaddeus and his team said that, look, you are giving us about 20 minutes to do all that. He has done almost 25 minutes. And they said, is that so? Let's give the Attorney General, you have 1 minute to wrap up. Then all those things came up.
A lot of back and forth.
Absolutely back and forth. Then they retired. And the decision was what we all knew.
What was the decision?
The decision is that if you look at if the Speaker is saying that, look, you know there was an issue that came that the Supreme Court or the Chief Judge has issued an administrative directive that the Speaker should be served on Mondays.
Yes.
Okay. And then the Speaker rejected processes served on him and said that, look, the Supreme Court or the Chief Justice directive said that serve me on Monday. And the processes were left wasn't on Monday, so then I have not been properly served. The Supreme Court says that when there is an administrative procedure and then the law automatically wins. And so for the Speaker to take that, it was a decision taken by Justice Enimiyebua, the directive, and the Chief Justice currently reviewed that process. And so if the Speaker is to be served on Monday and that was not done, in fact, the legal department of Parliament, any member of Parliament could be served in any other day. So once that has been done, it constitutes a proper service. And so the court is of the considered view that if Parliament is allowed, or Speaker, the ruling is allowed to stay, what happened to those who are occupying ministerial positions? It means their term should have been ended. Mm-hmm. What happened? Would they be paid anything? No. The people they were representing in their constituency will be left with no leader and order. So they think that in the interest of the whole thing that has been discussed, that particular request to have the ex-parte decision stayed should not be allowed. So Speaker's motion yesterday was rejected.
Been dismissed.
Yes, was rejected. It was declined by the 5-member panel. But we have the ruling. The ruling of the other Supreme Court.
Yeah.
Let's go on what the Chief Justice delivered that particular ruling yesterday.
Whatever interpretation of the circular that the Speaker chose to put on how he was to be served, the Supreme Court is satisfied that the Speaker was well served with notice of the action that had been started on 15th October 2024 and seeking the correct interpretation of Article 97(1)(g) of the Constitution. He was well served before he delivered his ruling on 17th October 2024 that would lead to the exceptional circumstances enumerated herein. And the Supreme Court carries the constitutional obligation to give the correct interpretation of Article 97(1)(g) for its enforcement, if need be, by the High Court or any person that the interpretation comes to. Hence, the scope of the orders made to stay enforcement of the Speaker's interpretation of Article 97(1)(g). Grant of orders beyond 10 days. The Speaker's lawyer urges that because of Order 25, Rule 1(8) of the High Court Civil Procedure Rules 2004, CI 47, that enjoins high courts to grant injunctions and other preservation orders for 10 days in the first instance if heard ex parte and without notice to one party summoned before the court. The Supreme Court was also enjoined to grant the ex parte order for 10 days as a matter of rules and practice. This is a submission that fails to appreciate the import of Article 2.2 and 2.3 and 2.4, which guide the Supreme Court when dealing with a constitutional matter such as this. We will quote again Articles 2.2, 2.3, and 2.4. The Supreme Court shall, for the purposes of a declaration under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to declarations so made. Any person or group of persons to whom an order or direction is addressed under Clause 2 of this article by the Supreme Court shall duly obey and carry out the terms of the order or direction. The Constitution enjoins the Supreme Court to make orders that are appropriate for giving effect or enabling effect to be given to its final declarations on the correct meaning of a constitutional provision. And the Constitution is so serious about ensuring the obedience of such orders that it creates the offense of high crime for failure to obey such orders in Article 2.4. Not even the President and Vice President are exempt from obeying the orders of the Supreme Court when they are made to give effect to its duty to prevent a violation of the Constitution. Because of the irreparable harm to the constituencies made up of hundreds of thousands of Ghanaians who would have lost their MPs without the option of a by-election, and the irreparable harm to the MPs who would have lost their seats in Parliament in these last few weeks to the 7th December elections, if the meaning put on Article 97(1)(g) by the Speaker was enforced without a clear determination of the disputes around it. This court found it expedient to compel the parties to allow an early hearing rather than make an order that would last only 10 days. This is the reason for the Supreme Court's orders abridging the 14 days allowed for defending a constitutional action through a statement of case and directing the parties to file their respective statements of cases within 7 days and present the issues for resolution immediately thereafter. If the parties had complied with the court orders, this would have taken all of the 10 days the applicant urges an ex parte order ought to last. Compliance would also have enabled this court to dispose of this case by this week, including the question of whether the suit is competent in form or the jurisdiction of this court has been properly invoked. It is important, and the question of whether the jurisdiction has been properly invoked is different from whether the jurisdiction exists. It's a different legal question. It is important to place on record that both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete hearing of this suit if the Speaker chooses to file no processes. For the above reasons, the application is refused.
So that is the Lady Chief Justice and the presiding judge in relation to this very case, Justice Gertrude Saki Tokonu, saying that, giving us all some of the reasons why they think that the application from the Speaker of Parliament should be refused, and same has been accordingly refused. What it means is that as it were, so shall it be, until such time that the substantive matter is dealt with. And
so at the end of it, there were some issues with regard to the substantive matter itself,
yes,
where the Speaker of Parliament was directing lawyers for, where the Chief Justice, I beg your pardon, was directing speakers' lawyers,
yes,
right, to file their processes by Friday. And there was some banter there, and the Attorney General also stepped in and made certain points, right?
So, yes.
What happened there?
So when the request was refused, now the court made the point that the Attorney General and then the Afenyo Markins lawyer, they have filed their processes, including memorandum of issues to be dealt with or to be decided by the court, but the Speaker has not done. Then the Attorney General, so they want to know whether the Speaker will file or not to file. If the Speaker will not file, the court will go ahead and give out a date for hearing and possible a judgment date. Then the Speaker said, Title said, I need to confer with the Speaker to know when or the next line of action and when we can follow. Then the Attorney General came in and said, look, all that is happening, one thing that the court ought to note is that the Attorney General, it's not for any reason that the Attorney General is a party to the case, because one, it has to do with government institutions and other statutory bodies. The Attorney General can act and stand for all these people. So the presence of Thaddeus Sorry representing the Speaker is unlawful. So at that particular point in time, you could see from the panel, there were a lot of moments that they were trying to jaw from one to the other. So there was that movement for quite a long time, close to about 10, 15 minutes. Then the decision was that, are they going to strike off the name of the Speaker so that it will be the Attorney General and Afenyo Markins? At a point in time, the CJ said, look, that decision should be taken by the substantive panel. And you know, this panel is 5. It's a constitutional matter. And constitutional matters are dealt with by 7-member panel. Yeah, 7-member panel. So this is not the original panel that would do. This is to deal with the interlocutory issues. So I'm going back. We'll come out with a substantive panel to come and deal with that issue. Then the earlier judges that I mentioned, the Chief Justice, Justice Maria Mawusu, Justice Samuel Esiedu, Justice GHOne, and Justice Yauda Sari, 2 justices were added, Justice Amadou Tanko and Justice Lovelace Johnson. So those were the 2 that added to make it 7. Then they came back. There wasn't any issue about that particular point made by the Attorney General. What they said was that they are giving the Speaker up to the 6th of October to file...
Of November.
November, sorry. To file the processes. Because the Speaker requested that after automatically, the matter was brought to the attention of the Speaker on the 21st of October. So you have 7 days. That 7 days elapsed yesterday. So if anything at all, Tadosori pleaded with the court. And then they gave me up to that 7 days back. So it's on the 6th of October. Then the court initially fixed November 11 for judgment. Then the AG made the point that, look, it will be fair that we come to court and make submission in relation to our submission that we have filed. Then the court can take it out from there, which they agreed. So in effect, that was what happened. And the case has been adjourned to the 11th of November for hearing, and then that day, a date will be fixed for judgment. But of course, when the case was over, we're speaking to some of the parties involved. First, let's hear from the Attorney General in relation to this.
I do not usually quarrel with the courts, and I do not have any complaints at all. Substantially, as you said, my objections, the points were upheld, and the sense is that the objections of the first defendant, the Speaker of Parliament, were without any basis whatsoever. And I think it's very important to indicate that this country sometimes there's a lot of ignorance paraded as wisdom. The situation where you have ignorance paraded as wisdom must stop. There's a lot of deceit and misrepresentation of reality to the public. You find all the points that have been made all the time. I listen to the radio quietly when this matter came. I've never spoken at all. And I see a lot of ignorance and mischief being perpetrated and being thrown in the eyes of the public. And you've seen it. I'm sure that is why the court took its time to deliver such a comprehensive ruling to educate the public properly and to prevent ignorance from being further paraded as wisdom in this country.
So that is Godfrey Ebuadami, the Attorney General. So he is saying that, look, there's been a lot of ignorance peddled out there ever since the matter came and he has not spoken. And he felt that the Supreme Court has seen the wisdom in that. There are a lot of people, ignorant people, who are parading themselves for people to see that they have wisdom in all of that. And he's responded clearly because the decision went in their favor. But of course, Afenyo Markin's lawyer, Pakwesi Abedu, has this to say.
Indicates clearly that today's ruling has narrowed down the issues for determination by the courts, in the sense that the first defendant, that is the Speaker of Parliament, now has no excuse whatsoever to decline or fail to file his defense and statement of case to the action. So now we are poised for a full hearing and determination of the matter. No more interlocutory or interim applications. The Speaker or any other arm of government or agency of government for that matter, by Article 88 of the 1992 Constitution, is mandated, I place emphasis on that word, is mandated to engage the attorney lawyer as its counsel in representation, whether in court or outside court. The circumstances under which they brought a private lawyer as their counsel cannot be answered by me. I leave that to them.
So, lawyer Pakwesi Abedu, counsel for Alexander Afenyo Markin. So, these are some of the reactions yesterday after the decision. For those who watch GHOne TV and listen to Star, will be familiar with some of the conversations, some of the banter. Yesterday, we didn't see so much of a banter as compared to during the hearing of the LGBTQ+, where the Chief Justice and then Tadosori were at each other. Yesterday it was relatively calm, but of course the battle of wit was evident. We had a lot of education yesterday, and there were lost students in the chamber, a lot of lawyers who even had cases, and those who did not have cases all want to come and hear what the argument will be. Because
this is a landmark case.
Yes, at one point we heard a Chief Justice say that we are in a crisis.
A constitutional crisis. So this is a landmark case. And
a very long time, Parliament is not sitting. Well, they think that they want to deal with the case expeditiously. And I won't be surprised on the 11th, they can fit the 12th to say that they are going to deliver their judgment because they want all these things done very, very fast and all that. So now the whole process, all the interlocutory issues have been settled. So what is left is the substantive matter, which the speaker's lawyers or the speaker will have to file processing by the 6th. And then the 7-member panel, like I mentioned, the Chief Justice will be chairing, Justice Mariama Owusu, Justice Samuel Esiedu, Justice Amadou Tanko, Justice Loveland Johnson, Justice Ernest Gawu, and Justice Yao Dakun Asare. So these are the justices who will be dealing with this landmark, like you mentioned, case.
All right. So that's not the only thing that happened in court yesterday. The case involving Bishop Salifu Amoako and the unfortunate death of 2 individuals.
Yes.
What happened in that case?
Yesterday, that case came up for the second time. You could see on your screen, that is Salifu Amoako and the family, the wife, and then the sales assistant. I don't know why they have covered their hair with the scarf, but they do not want their faces to be shown. Apart from Salifu Amoako, whose face was shown, the rest were all in the hard scarf.
Were there any rowdy supporters of Salifu Amoako this time around?
Yesterday, they were nowhere to be found. Yesterday, those who assaulted me, they were nowhere to be found. So yesterday, they came with some senior church members or some of the pastors, some of whom came to our office here to apologize and all that. But the people who were involved in that inhuman acts, none of them was on the premises of the court. I was on the lookout for them. And unfortunately, yesterday, they didn't come. So that was what happened. But when the case was called, Salifu Amoako, the wife, through their lawyer, informed the court that there's some concern that they need to bring to the attention of the court, which is that the minors' pictures and videos are being circulated in the media, including one that he was being operated on. And so under the Juvenile Justice Act, Criminal Justice Act, it protects a minor from all these instances. So the court will make an order to stop all these things from happening. Or in fact, those who have done it should have it deleted from the system. The Attorney General's rep said, look, I agree largely with what counsel for the accused were first and second, Salifu Amoako and the wife, have said. However, we do not know who the order should be made at. Then the counsel came back to say that it should be made to all media houses, the police, and the police hospital, because they felt that whatever is coming out will be from these institutions. Then the court said, look, the case before me, there's no case of a minor before the circuit court. So what you are saying, me, I don't know. You are mentioning a juvenile. There's no juvenile here. So if I'm making an order, what kind of order am I going to make? However, the Ghana Police Service, the police hospital, should ensure that there's nobody giving access to where the child or is undergoing treatment, so that they can have the opportunity to take videos and pictures and all that. And if there's anything, they can write to the police administration to make a formal complaint, and they can do an investigation from that. So this case has been adjourned to November 13, and then prosecution requested for time, 2 weeks, to file a disclosure document and then a witness statement. So that's what happened before His Honor, Mr. Samuel Bright Aqua, yesterday.
All right. We'll see what will happen as this case unfolds. But finally, today, there is going to be another televised Supreme Court. We are going back to the Supreme Court today.
We are going back to the Supreme Court today.
So it will be back-to-back sittings for the Chief Justice and her panel. And this time around, it's a different panel, right?
No, it's a different panel. It's a different panel.
Different panel.
Yeah, it's a different panel. But of course, the Chief Justice is presiding over that same panel. Yeah, it's a different panel by the Chief Justice. So the anti-gay cases, another case that has really a lot of controversy. Sam George and his men stormed the streets, protested against the judiciary, and said that, look, you are delaying the cases because of a decision you took earlier by not giving us a definite decision on the interlocutory injunction. That, for that matter, that bill, which was passed as far back as in February. February tonight, how many months? February, March, April, May, June, July, August, September, October. So that's 8 months. Because it was passed around the very last day of February, right? So that's 8 months now. They are saying that, look, It's been a long time, and that bill is sitting on the desk of the Speaker. It could not travel to Parliament because of the pendency of these two cases. Richard Delaskai has one, and a researcher, Dr. Amanda Odoi, also has one. Today, 7-member panel of the Supreme Court is sitting, and like you mentioned, it will be live everywhere. Once you are, you stay glued to GHOne TV and Star.
So is this on the substantive case?
This is on the substantive matter.
Substantive matter. So they will
hear. They will hear the matters. Yeah, two separate cases will hear, because
they
the
may
last
or
time,
may not give a ruling on it, or
it depends on the directive that the court will give. If they feel that everything that has been filed now, it said is enough. Like yesterday, the parties will be given opportunity or time, 5 minutes, 10 minutes, to highlight some of the key things that they want the court to take note of, some precedents or authorities that the court will want to avert its minds on. They will do that. But we'll know more whether indeed the CJ has made us understand that before a case is listed, it means it is ripe for hearing. And we think that per the notice that have been issued, this case is meant for hearing. And once it is heard, and there's if their minds are already, they are convinced that whatever has been filed, they have enough to deliver their decision on, we'll get to know. But what is clear is that Richard Delaskai and Dr. Amanda Odoi are at the Supreme Court today, and in respect of the LGBTQ+. So we'll know more later in the day, as the Supreme Court says. And it's to be live on our channels.